The judge versus lawyer battle of the YSL trial is heating up. Last week, some of you watched me blind react to attorney Brian Steele being held in contempt and arrested during the trial. And some of you hated my takes.
They ask you how you are, you just have to say that you're fine.
But that's okay, because we're going to talk about it today, as well as the fact that since then, attorney Steele has tried to get Judge Glanville to recuse himself, and he was denied. Well, let's break it down. We are currently on day 95, 96, 238, 365, I don't know, of Young Thug's YSL trial. Georgia's longest trial ever. And so much has happened outside of Young Thug's charges. It's pretty crazy. This all began 2 years ago when Young Thug, whose real name is Jeffrey Lamar Williams, was arrested and indicted along with 27 other people with 56 counts of crimes ranging from robberies and shootings to homicides and even more than that. And all charges related to Young Thug's alleged connection to the gang Young Slime Life. That trial has been going on now for 18 months, and it has not been a smooth ride, and it's not almost over either. But the latest bump in the road is the ongoing battle between Young Thug's defense attorney Brian Steele and the judge assigned to the case, Judge Glanville. As I mentioned last week, this all began with the testimony of a key witness named Kenneth Copeland. Now, Copeland was a YSL associate who had agreed to take an immunity deal so that he would not be charged for violating his probation. But once he made it on the stand, he refused to answer any questions, pleading his Fifth Amendment rights. Judge Glanville reminded him of his immunity deal, which protected Copeland from being prosecuted for any information that he revealed as long as he was truthful, but Copeland continued. He was held in contempt and he spent the weekend in jail. Upon making it back to the courthouse on Monday, June 10th, an alleged ex parte meeting, that means not both sides present with the judge, was held between Copeland, the prosecution, and Judge Glanville. But notice who was missing: no Williams' attorneys. A meeting in which attorney Steele had alleged that Copeland was threatened illegally in order to force his testimony. Now, I had some strong opinions about what went down in the courtroom after attorney Steele revealed that he knew about the secret meeting, and some of you disagree with me. That's fair, that's fine. I think attorney Steele did a good job of explaining who he believes was there in the room. Here's what attorney Steele says is the likely illegality of that meeting in the judge's office without Williams or his lawyers present, according to the motion that he filed. Uniform Superior Court Rule 4.1 and Georgia Code of Judicial Conduct 2.9 delineate rules governing ex parte communications. Uniform Superior Court Rule 4.1 generally prohibits ex parte communications. And then here's the quote from the rule. Except as authorized by law or by rule, judges shall neither initiate nor consider ex parte communication by interested parties or their attorneys concerning a pending or impending proceeding. He goes on to argue that ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial proceedings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. The attorney then goes on to cite two cases that he says stand for the propositions that he's made in his argument. He also then goes on to quote Rule 2.9 at length. And as I said last week, and some of you hated this, it is in fact possible that the meeting was not illegal. It seems unlikely, but it was possible. Again, we haven't heard anyone argue for the legality of that. We don't know what the prosecution would say, and you don't want to hear like argument from a judge, but we don't know what the judge would say either. But Rule 2.9 does seem to be very, very clear that the judge has to let Williams and his attorneys know what happened during the hearing. Full stop. And he hasn't done that. Now, where attorney Steele runs with this apparent non-compliance by the judge with this particular rule is that the judge must be on the prosecutor's side of the case, and he's just trying to make certain that Williams gets convicted. And that may be true. I don't know. I don't think Steele knows either, but it's not a crazy take. It's really not. But we just don't know yet. But remember, Steele has been sitting in the courtroom with this judge day after day, week after week, watching these things that he says seem unfair to him. But since by all accounts the court reporter was in the meeting, eventually we all should know what was said by whom in that meeting. We should, but it is possible that if the judge or the prosecutor said something that was like totally illegal or intimidating to the witness, to Mr. Copeland, it's not beyond the realm of possibility that those statements don't show up on the transcript. For instance, if there was no actual voice recording, there might have been multiple people talking at once in such an informal setting, and the court reporter has trouble taking notes of the most illegal things just by happenstance, especially if it was the judge who said it, if you know what I mean. Now, when I was a young lawyer, I was told by an older lawyer that it was common knowledge among the lawyers in this one area where I practiced that when a certain judge got angry on the bench, which he did a lot, and said things which a judge ought not say, that the court reporter's notes wouldn't capture all of the fecundity of his language. In short, there are some possible ways that by his own staff, a judge could be protected if a court reporter is making a record and doesn't necessarily include everything. Now, I hope that was not true, but of course it's possible, especially if a judge tells a court reporter, hey, when I say illegal, crazy stuff, don't write it down. But the upshot of all of this is that we want the recordings of the chambers meetings, and we want them now. Whatever happened in there will shed light on the current situation, and Rule 2.9 seems unambiguous that the judge is required to let the excluded parties know about the substance of the conference. Maybe we don't get the full transcript, maybe we get a summary, maybe we get a redacted copy, but we gotta get something. Let's talk about what's happened since Steele was arrested in order to spend his next 10 weekends in jail. First and foremost, the Georgia Supreme Court granted a motion for bond, which means Steele won't be spending his weekends in an orange jumpsuit, and his appeal is still pending. Secondly, Steele filed a motion to disqualify Judge Glanville from the trial because of the ex parte meeting. Georgia has a great system, at least on paper, for review of motions to recuse. Just to be clear, a motion for recusal is where a party asks a judge to, on his own, just step away from the case. The Georgia law says that the judge to whom the motion is made, which is the same judge who's also the subject of the motion, that they must assume that the facts asserted in the motion are true. And if so taken as true, would a reasonable person have a basis to question the impartiality of the judge? That's a great standard because you don't have to prove that the judge is actually biased. Just that a reasonable person might think that he could be or that she could be. And then taking the facts as true, the judge basically has three options. He could give the motion to another judge to rule on. This should be the normal course of action. He can recuse himself. This is for a judge with a lot of humility and who wants to honor the legal system when possible. Or finally, he or she can just deny the motion. But that's not a great look. There are hurdles for these motions. For instance, in Georgia, if something happens that you think shows the judge is biased or could show that the judge is biased, you have only 5 business days to file your motion for recusal. That's a very, very short time. So if there's this just drip, drip, drip of unfair behavior during a trial, only the things in the last 5 days are within what is effectively a statute of limitations to complain about it. And that's not without risk, because if the judge does deny the motion, or if another judge denies the motion, then you're stuck with him or her. A denied motion of recusal during a trial is a little bit like if you were trying to break up with your boyfriend on day 2 of a 7-day vacation. Ladies, that's awkward. Steele's motion accuses Judge Glanville of showing a bias against Williams and his representatives, meaning the lawyers, and cited this ex parte meeting as a big part of that. And then, of course, the ridiculous ways in which Attorney Steele was treated after the meeting, in open court, trying to jail him, and whatnot. And what did Judge Glanville do with this motion? Denied. Oh, Judge. Oh, the judge said the claims in the motion were insufficient and then proceeded to deny the motion. Oh, Judge Glanville. Judge Glanville, what are you doing? This is not a great look. Let's just workshop this for a minute. You have the ability to give the motion to another judge. And let's do this above board, okay? let's say you're a judge and you really don't care. You just want justice. You give it to another judge to rule on. If that judge kicks you out of the case, fine. You didn't admit to doing anything wrong. They're not saying you did anything wrong. They're just saying a person might think that you did. But if this other judge, who isn't you, isn't biased, approves of what you've done and says, no, you should stay on the case, then you're golden. It's a different judge. And you probably eliminated a significant argument on appeal for saying that you should have recused because you gave it to someone else and they recused you. The reality is that inside these courthouses, a lot of these judges are friends. They just are. They're people. And they talk. And I can imagine that judges would try to help each other out. I'm not saying that they do. In fact, because I'm a lawyer, I'm specifically saying a judge would never do that. But like a human would do that. All right? But let's assume they don't. Man, just give the motion to another judge and let them rule on it. And then Steele doesn't have as great of an argument that you're treating him badly, and Williams has less arguments for appeal. And if the judge really does want Williams to get convicted, then taking out ways for him to appeal successfully would be a big brain move. This case has gotten crazy. The fact that Glanville tried to jail him and then got reversed is one of the wildest things that any lawyer has ever heard of. And I shouldn't say he got reversed. The reality is it's kind of stayed pending additional ruling, but he's not in jail now. And to be clear, patient judges go out of their way to never make a lawyer look bad in court in front of a jury because they want the jury to see that the judge is impartial and that the jury itself must make up its mind. If the jury finds out in any way about these crazy shenanigans with Steele, that's a very, very polarizing look. Now, I'm not saying it would necessarily even be bad for Williams, because if someone on the jury is one of those people who thinks that like the system is just rigged to get certain people, or that if they put someone on trial, they're always going to make it so that you've got to convict them or whatever, then the mistreatment of Steele might actually further their kind of theory that the whole thing is rigged, and they might vote for an acquittal. There are different ways for juries to take it, but it would be some really odd information to receive as a juror that the judge was trying to put one of the lawyers in jail and failed. As the longest trial in Georgia's history, the thought of having to start over from scratch must be weighing heavily on the minds of the prosecution and the defense and even the judge. But what is on your mind? What are your thoughts about Attorney Steele's motion and Judge Glanville's decision? Drop your pro se opinion down below in the comments. Let me know what you think. And just like Judge Glanville, I reject your motion to recuse from my videos. You are now ordered to hit the subscribe button.